Good to see you're back with me, YouTube. As I was saying before the camera once again rudely cut me off, studies by Jeffrey Segal and Harold Spaeth show that justices tend to vote in line with their political attitudes. Now, skipping ahead to the summary line because the rest of it's very boring and I've read most of it too, Segal and Spaeth concluded that policy preferences of the justices go a long way towards explaining their decisions. It is true, of course, that disputes that reach the Supreme Court are anything but clear-cut. If they were, they would have been settled in lower federal courts. Nevertheless, Supreme Court decisions are a mix of law and politics. Arguably, partisanship was never more evident than in Supreme Court's Bush v. Gore 2000 decision that blocked a manual recount of the Florida presidential vote in 2000, thereby assuring the election of the Republican nominee, George W. Bush. The five justices in the majority, Chief Justice William Rehnquist, and Associate Justices Sandra Day O'Connor, Anthony Kennedy, Antonin Scalia, and Clarence Thomas were Republican appointees, and were the same justices who in previous decisions had deferred to state authority and had opposed new applications of the 14th Amendment's Equal Protection Clause. Yet they rejected the authority of Florida's highest court, which had ordered a statewide manual recount of the vote. They also devised a never-before-used application of the Equal Protection Clause, concluding that the recount could not go forward because no uniform standard for counting the ballots existed. Justice John Paul Stevens, who thought Florida's High Court had acted properly in ordering a recount, accused the court's majority of devising a ruling based on their partisanship rather than on the law, saying that the majority had ignored the basic principle inherent in our Constitution and our democracy that every legal vote should be counted. Stevens noted that different standards for casting and counting ballots are used throughout the country, even within the same state. Outside the courts, the public groups, and elected officials, the courts can and do make unpopular decisions. In the long run, however, judicial decisions must be seen as fair if they are to be obeyed. In other words, the judiciary cannot routinely ignore the expectations of the general public, interest groups, and elected officials. Judges are less responsive to public opinion than are elected officials. Nevertheless, the Supreme Court in some instances has tempered its rulings in an effort to get public support or reduce public resistance. The Supreme Court usually stays close enough to public opinion to reduce the likelihood of... What do they reduce the likelihood of? To reduce the likelihood of outright defiance of its decision. In the 1954 Brown case, for example, the justices, recognizing that school desegregation would be an explosive issue in the South, required only that desegregation take place with all deliberate speed, rather than immediately or on a fixed timetable. After its Swan v. Charlotte Mecklenburg Board of Education, 1971, the school busing section led to riots in several cities. The court held in Milken v. Bradley, 1974, that busing around school district lines would not be permitted. The Milken decision effectively insulated suburban school districts from busing, which served to reduce white suburbanites' opposition to the policy. Interest groups also have an influence on the judiciary. Groups petition the White House and Congress to appoint judges and justices who share their outlook on legal disputes. More directly, they submit amicus curiae, friend of the court briefs, to make their positions known on court cases, and file lawsuits to advance their policy goals. Some groups, in fact, rely almost entirely on legal action, knowing that they have a better chance of success in the courts rather than in Congress or the White House. The American Civil Liberties Union, look at my nose twitch, see it? It's more mouth twitch there, isn't it? The American Civil Liberties Union, or ACLU, for example, has filed hundreds of lawsuits over the years on issues of individual rights. In 2010, for instance, the ACLU filed suit to force federal agents to meet constitutional requirements for search and seizure before they could examine documents stored on travelers' laptop computers. Groups that rely on judicial strategy pick their cases carefully, choosing those that offer the greatest chance of success. They also carefully pick the courts in which they file their lawsuits, knowing that some judges are more sympathetic than others to their arguments. Elected officials also have ways of influencing the courts. Congress can rewrite legislation that it feels the judiciary has misinterpreted. Meanwhile, the president is responsible for enforcing court decisions and has some influence over the cases that come before the courts. Under President Reagan, for example, the Justice Department vigorously pursued lawsuits that challenged the legality of affirmative action, a tragedy consistent with Reagan's determination to limit its use. Judicial appointments offer the President and Congress their biggest opportunity to influence the courts. In 2008, when it became clear that their party was likely to win the presidency, Senate Democrats slowed action on the confirmation of President Bush's judicial nominees. When Barack Obama took office in 2009, scores of judgeships were vacant, which he filled with loyal Democrats. It was a tactic Senate Republicans had employed in 2000. They had delayed action on President Clinton's nominees, enabling Bush to appoint Republicans to existing vacancies when he took office in 2001. As a result of heightened partisanship in Congress, the judicial appointment process has become increasingly contentious. Democratic and Republican lawmakers alike recognize the power of the courts to determine policy in areas such as affirmative action and environmental protection. Each party lawmakers have been determined to confirm judicial appointees whose policy views align with their own. Nevertheless, the influence of elected officials on the judiciary is never total. Judges prize their independence, and their lifetime appointment insulates them from political pressures. In 2004, for example, the Republican-laden Supreme Court rejected the Bush administration's claim that it had authority to jail suspected terrorists indefinitely without a court hearing. An interruption from political thinking. Why more liberal? Like the Jokers. Why more serious? But not like that at all. Supreme Court justices typically take ideological positions that are roughly in line with the expectations of presidents who appointed them. The expectations, such as recently retired Justices David Souter and John Paul Stevens, who were appointed by Republican presidents, have tended to be more liberal than were expected, particularly on issues of civil liberties. Do you think that is coincidental, or does it suggest something basic about the court's role in protecting the rights of individuals? How very curious. Back to judicial power and democratic government. Federal judges are unelected officials with lifetime appointments, which places them beyond the reach of the voters. Because the United States has a constitutional system that places limits on the court's majority, the judiciary has a legitimate role in the system. Yet court decisions reflect in part the personal political beliefs of the judges. A basic question is how far judges should go in substituting their judgment for those of elected officials. The power is most dramatically evident when courts declare laws enacted by Congress to be unconstitutional. In such instances, unelected officials are substituting their decisions for that of the people's elected representatives. The difficult process of amending the Constitution, two-thirds majorities in the House and Senate, and approval by three-fourths of the states are required, making such amendments as an impractical means of reversing the Supreme Court. During the past century, only one constitutional amendment, the 16th, which provides for a federal income tax, has been adopted in reaction to a Supreme Court decision. The judiciary's power has been a source of controversy throughout the nation's history, but the debate has seldom been livelier than during recent decades. The judiciary at times has acted almost legislatively by addressing broad social issues such as abortion, abusing affirmative action, church-state relations, campaign finance, prison reform. During the 1900s, for example, the prison systems in 42 states were operating under federal court orders that mandated improvements in health care for reductions in overcrowding. Though actions the judiciary has restricted the policy-making authority of the states, has narrowed legislation discretion, has made judicial action an effective and political strategy for certain interests. The judiciary has become more extensively involved in policymaking for many of the same reasons that Congress and the President have been thrust into new policy areas and become more deeply involved in old ones. Social and economic changes have required government to play a larger role in society, and this development has generated a seemingly endless series of new political controversies. Environmental pollution, for example, was not a major issue until the 1960s. Since then, it has been the subject of innumerable court cases. How far should judges go in asserting their interpretations of the law, as opposed to those put into effect by the people's elected representatives? What is the proper role of an unelected official in a system rooted in the principle of majority rule. There are competing schools of thought on this issue, none of them which is definitive. The Constitution is silent on the question of how it should be interpreted, which has left the judiciary's proper role open to dispute. Nevertheless, a brief review of the major competing theories is instructive. Now, I'm just going to take a quick sidebar for how the US differs political thinking through comparisons. I refuse to read this because I already read it. I found it dull and boring and contrived. But that's just me being terrible because it's late at night and I'm mean. Basically, it says that we're different because we can use judiciary review. This is varying from Europe, who also has the Supreme Court. However, their Supreme Court cannot deem actions unconstitutional in any area of government, only specific areas. That is how the US differs. Anyway, back to the actual text. Originalism theory versus living constitution theory. Originalism theory, a prominent philosophy of conservatives, holds that the Constitution should be interpreted in a way that a reasonable person would have interpreted it at the time it was written. Originalists emphasize the wording of the law, arguing that the words of the framers are the only reliable indication of how the law should be interpreted. As Supreme Court Justice Antonin Scalia, an avowed originalist, has said, "You figured out what the Constitution was understood to mean when it was adopted, and that's the end of it." The difficult part, Scalia claims, is trying to figure out what the words meant to those who wrote them and ratified them. It has required immersing oneself in the political and intellectual atmosphere of the time, somehow placing out of mind knowledge that we have, which an earlier age did not. An opposing theory, embraced more often by liberals, holds that the Constitution is a living document that should be interpreted in light of changing circumstances. Proponents of the living Constitution theory claim that the framers, through the use of broad language and basic principles, intended the Constitution to be an adaptable instrument. They cite the preamble of the 1787 Constitutional Convention's Committee of Detail, which says the Constitution ought to be accommodated to times and events. Supreme Court Justice Stephen Breyer embraces this view, saying that the judiciary should promote in today's world the kind of government that the Constitution was meant to establish. The Constitution, Breyer, something, the ice cream, provides a framework for the creation of democratically determined solutions, which protect each individual's basic liberties, while securing a democratic form of government. Critics of the living Constitution theory argue that in practice it allows judges to promote their personal views by enabling them to devise arguments that support the rulings they prefer. Such judges are said to turn the law into what they want it to say, rather than what it actually says. On the other hand, critics of originalism theory say the framers, in using broad terms such as search and seizure, could not have possibly have had practices of their time solely in mind. If that is what the framers intended, it is said they would have expressed the provisions in specific terms. The only plausible reason for why the framers used general terms and invoked broad principles was their recognition that society and law necessarily involve. What? I don't understand. But I'm going to cut this below the 15-minute mark, where my camera will automatically cut me off, because it's rude, and I don't appreciate when the camera does that, and I don't even get to finish my sentence. Anyway, I'll be back for part 5, and spare no cry, YouTube. You only have, let's see, a few pages left, and I'll skip over a large chunk of another page because it's another one of those pink texts that doesn't really add to the main text. It's silly, but I'm getting ahead of myself. Have fun for now. I'll see you in part 5.